Welcome to my YouTube channel. I am Professor Satya Prakash. In my last lecture, I discussed the one of the thinkers of historical school of jurisprudence, Savni, who propounded the Volksgist theory. The second thinker in historical jurisprudence is Sir Henry Maine, who lived between 1822 and 1888. He wrote a book in 1861 titled Ancient Law. He was a scholar of Roman, English and Indian law, and he is considered to be a thinker or writer on comparative jurisprudence, and his theory or school is also known as Anthropological School of Jurisprudence. Anthropology means the study of man in society in historical perspective. He said that there are two types of society. Every society passes through four stages. First is the stage of lawmaking by themist or goddess or divine law, or by the rulers as representative of God, which is known as the law making through personal judgments, personal judgment of the ruler or the monarch. The second stage is crystallization of custom, crystallization of personal judgment into customs, when initially the ruler or the king as representative of God decides or lays down the principles of law and justice, and when similar cases come forward and in the long term or long run the personal judgment are crystallized in the form of customs. Custom means a rule of law being observed in a particular society for a long time, immemorial time. So the personal judgments convert into the custom with the long usage of those personal judgments. The third stage is lawmaking by few people or oligarchy or aristocratic class of people. And the fourth stage is consolidation or codification of law by the majority of the people, like the 12 tables in Rome came into existence before the Christ. He said that all societies pass through these four stages, and if a society further passes through legal fiction, equity and legislation, then it is known as progressive or dynamic society. A society which ends its development till the four stages I discussed above is known as static society. The society which further passes through legal fiction, equity and legislation is known as a progressive or dynamic society. These development must be in this sequence only. The first is legal fiction. Fiction means that it is imaginary, or though the law does not change, but the impact of law changes. There is application of a fiction or imagination that though there is in reality the particular facts are not existent, but in imagination or by fiction, they are considered as different. Like, for example, the adoption of someone in Rome and India, the adoption of son was popular. The son becomes the legally becomes the son of the adopting parents, or in and does not remain the son of the natural parents. In India, there is adoption of boy and girls both, and thus the adopting father become the guardian or the father of the son or girl, and the natural parents do not remain the parents of the son or daughter given in adoption. Secondly, the equity. Equity developed in Europe because in common there were two types of laws, or the two types of codes. One was common law codes, the other category was equity codes. In England, the when the cases came before the common law courts, and if there is no law about providing redressal of the problem or redressal of the wrong, then the king used to refer, either the king used to decide the case himself or referred it to the chancellor. And later on, such type of courts developed which were known as equity. The chancellor or the king used to decide the cases on the basis of equity and common sense. Later on, it became the principle of equity, justice, and good conscience. In England, the two types of courts remain in existence till 1873, though the Britishers in India tried the amalgamation of the common law or civil law courts and the equity jurisdiction in Regulating Act 1773, 100 years before the application of amalgamation of common law courts and equity jurisdiction with the common law courts in 1873. And then the third stage for dynamic or this progressive society is legislation. Legislation is the modern source of law, and it is the highest method of legislation, and this was supported by Bentham also when he said that legislation is science. So these are the 7 stages, and the societies which remain till the 4 stages, those are known as static society. The society which further develop up to the 7th stage, that is legal, fiction, equity, and jurisdiction also, they are known as progressive or dynamic society. He gave a dictum or a statement that in 1861 in his book Ancient Law, that the movement of progressive societies has hitherto been a movement from status to contract. Means that till 1861 the movement was from status to contract. Status means that an individual has no personal status, but the individual is known as by the group, by the family, by the community, by the area to which that particular individual belongs. So previously everyone was identified by the status. Later on, by the by 1861, the movement became or converted into the status to contract, means the individuality came into existence or came into popular concept, and everyone is known as individually, and he or she can do everything in his or her individual capacity. The in Roman, because I said that Henry Maine was a scholar of Roman, British and Indian society. In Roman society as well as in the Indian society, there was a concept of head of the family. So the family was known as the status of head of the family, and there was no individual status or capacity of the member of that family. But later on, the movement was from status to contract. And for example, the relation of master and servant, or the in but later on, after 1861, there was a reversal of the movement. Before that, the person was known as from the membership of some community like tribes, but after 1861, the movement, there was a reversal in the movement. The movement became from contract to status. Though Henry Maine said that he used the word hitherto, means till 1861 when he gave his theory, the movement was from status to contract. But in the 19th and early 20th century, there was a reversal of the movement from contract to status. It was mainly due to two factors. One was industrialization, and the second was the recognition and the activity of the political parties in the state system of any state. So due to industrialization, certain specific laws were made for the protection or regulation of the conduct of the workers, like Trade Union Act. And if there was a declaration by the trade union officials or office bearers that there we go for a strike, then no member of the trade union can say that he or she will not be on strike. So again, there was movement from contract to status. And like that, in the political parties also, if a person is member of political party, and though he does not completely agree with the ideal or the ideas or the discussion taking place within the party, but once a decision has been taken, no member of the political party can claim that he is not in agreement of that decision. So the individual status of a member of political party diminished, and the status of political party became the main thing to be considered in the society. Then, but in the 21st century, or in the last of 20th century, the movement again became from status to contract. It was due to privatization and due to some self-financed or unorganized sectors, especially like education sector, where we have number of institutions, private universities or private or self-finance colleges affiliated with some, even with some state university. But the terms of employment, though declared by the governing body, whether it is UGC or the state government or the university with which the institutions are affiliated, the terms and condition of employment or service are different for all the employees. The one, if there are 10 teachers in a college, then their salary may be different from one another. Their condition of service may be different. So, due to unorganized private sector, development of private sector, which is mainly unorganized, there is no organized rules or regulation or authority to control them, or if there is authority, they are not capable of controlling them. So again the movement was from status to contract. So but Henry Maine was right in his assertion that there was movement of society from status to contract till 1861. So the one more important point about Henry Maine is his views about public international law. He, generally the positivistic thinker, says that there cannot be a positive law without sanction or without authority of punishment or without having an element of evil consequence. So, but thinkers or writers like Sir Henry Maine said that fear or punishment is not the very essential part of the application and implementation of law. Most of the people obey law as a matter of habit. The punishment or compulsion is meant for few people who are considered to be regular criminals or lawbreakers. But generally, it is the habit of people to obey law. So, in this sense, he supported international law, that there need not be a sanction or some authority to apply international law through fear of punishment. Bentham said that a progressive society is that where laws are made for the betterment and upliftment of women and children. This was Bentham's lifespan was from 1748 to 1832. So, in so much developing or a concept which favors women and children was developed by Bentham during the early 19th century. So, this is about Sir Henry Maine or Anthropological School of Jurisprudence, which is studied under the historical school of jurisprudence. Earlier I said that there are two thinkers in historical school, but we study Hegel also under historical school. Hegel gave the concept of dialectic interpretation and the idea of thesis, antithesis, and synthesis. So, in my next lecture, I will be discussing the concept of Hegel. With these words, thank you very much. I